Okay, in this video today I want to discuss the Gemma and John Waters Court of Appeal against the High Court decision to throw out their claim that the COVID laws and COVID regulations introduced by the government in Ireland were unconstitutional. I've already made a video or two videos about this particular case involving Waters and O'Doherty's challenge to the laws and regulations brought in to regulate people's movements and so on and so forth. They argued it was unconstitutional. The High Court found that that was not the case, and as I say, I've made a couple of videos about that and you can find them on my YouTube channel. In this particular case though, yesterday, Wednesday the 20th of January, they were appealing that decision to the Court of Appeal. Now, as it happens, the figures for COVID-19, and just to put this in context, up to a few days ago, there was 2,708 fatalities from COVID-19 since the pandemic started. There was, I think, 69 deaths yesterday. I think there was nearly 100 deaths the day before, and the figures yesterday, for example, for new infection rates were over 2,500, perhaps 2,700 or thereabouts. But to put the case in context and to put some of the assertions put forward by O'Doherty and Waters in the Court of Appeal in context, it's nearly 3,000 deaths in Ireland from COVID-19 since the start of the pandemic. In any event, how did they get on with the appeal? Firstly, there was a number of arrests yesterday because of the breach of public office or public order regulations and regulations to do with social distancing and so on and so forth, down around about the four courts, and those people were there, I understand, in support of Gemma O'Doherty and John Waters' appeal, having been encouraged to come along by various notices and so forth on Twitter, etc., etc. But as for the case itself, some of the decisions or some of the assertions and some of the claims made by Miss O'Doherty and John Waters are absolutely mind-boggling. I'm referring here to the legal affairs correspondent of RTE, Orla O'Donnell, and her report of the case. The Court of Appeal has reserved its decision, hasn't indicated when it would give its decision, but the two, O'Doherty and Waters, claimed that COVID-19 is a common cold, described it as an alleged virus and an alleged pandemic. They claimed that the measures taken by the state were based not on science but on conjecture. They said that most people did not know anybody who had COVID-19 or who had died from it. And they were arguing or asserting that the public health laws brought in by the state were unconstitutional and flawed. They said that the state had decided to embark on a completely new path, never tested before, etc., etc., and they had asked for evidence that the lockdowns, the masks, social distancing and so forth were justified. Miss O'Doherty said these measures were based on nothing more than conjecture. But Miss O'Doherty and Mr. Waters seem to have a fundamental misunderstanding of how the legal system works in terms of a challenge at judicial review, because it was not for the state to justify, it's for them to overturn the decision of the High Court, and they singularly failed to do that. But as I say, some of the claims, some of the assertions that they made were absolutely remarkable. She said, Miss O'Doherty, that the average age of death from coronavirus was 83. That was the age of life expectancy, and the vast majority of Irish people would not be affected by the coronavirus. She said most people who had died had underlying conditions and their time was up anyway. Miss O'Doherty went on to claim there was a cure for the virus from hydroxychloroquine, vitamin C and zinc, but hospitals were putting people into intensive care and bringing about their deaths. These are remarkable assertions, remarkable claims, not a scintilla or a particle of evidence, however. She said she'd gone into the hospitals as an investigative journalist to see with her own eyes where the pandemic was. They had been empty since last March, she claimed. Miss O'Doherty stood in the Court of Appeal yesterday in this state and claimed that the hospitals were empty since last March. Just think about that. Mr. Waters then compared Ireland's response to the World War II emergency to the current situation, and he was advised by Mr. Justice George Birmingham that he might be better advised to concentrate on the current situation and leave the past to the past. Mr. Waters told the court that the onus had been put on them to show the disproportionality of the measures taken by the state. He said it was their case that it was up to the state to justify the proportionality. That is not the case. In response, Senior Counsel Michael Collins said Mr. Waters and Miss O'Doherty had failed to understand the test for success in such proceedings, that applicants must establish that they have an arguable case with a reasonable chance of success. They had singularly failed to do this in the High Court, and they have, according to this report, made precisely the same mistake again. They've got in there making speeches, making assertions and so forth without a scintilla of evidence. They must, Senior Counsel Michael Collins said, adduce actual evidence to support their argument. He said they seem to have misunderstood that burden was not on the state to justify and explain the legislation, but on the applicants, Miss O'Doherty and Mr. Waters, to establish why they had an arguable case. They don't even have to prove their case. All they have to do is show that they have an arguable case. It is very unlikely from the assertions that they made in the Court of Appeal yesterday, in my view, that they will succeed. The Senior Counsel for the State then went on to set out the reasons for the legislation. There was a manifest and grave risk to human life and public health. The reality of the pandemic and its effect on society were evident, he said, and the concern of the Oireachtas was fully justified. Mr. Collins said this was an appeal against the High Court ruling. There had to be some identification by the appellants of some error in the High Court judgment. Yet there was no identification of such an error. All there was more bald assertions. He said judicial review proceedings were not appropriate to challenge the constitutionality of regulations when no underlying decision of a state body was being attacked. The nature of this challenge, with its sweeping generalised references to largely unidentified experts and reports, showed why Mr. Waters and Miss O'Doherty had not established even an arguable case that the legislation was unconstitutional. And then 11 people were arrested at protests outside the court. Bottom line is, this Court of Appeal decision, or this Court of Appeal challenge by Waters and O'Doherty, seems to be a reheating of the same wild assertions that they made in the High Court and which failed abjectly in the High Court. They seem to have learnt nothing from it. They seemed to have no evidence whatsoever. They didn't have evidence in the High Court. They don't have evidence in the Court of Appeal. It is almost certain that their Court of Appeal challenge will fail. It's almost certain they'll go on to the Supreme Court, and it appears to many people that what these people are engaged in is a brazen attempt at self-publicity and self-promotion, and that they have simply become besotted with being in the public limelight, no matter how odious the coverage is, no matter how they are viewed, no matter how odious their assertions are. And just to claim or to assert again or to reiterate, to claim that COVID-19, which has killed over 2,500 people since its commencement in the state, is a common cold. To claim that it's an alleged virus, an alleged pandemic, is palpable nonsense, and it is an insult to people who have suffered from COVID-19. It is an insult to the families who have suffered fatalities, and it is an insult to all of the people all around the world who have clearly suffered from COVID-19. And in the United States, where the death toll is over 400,000, to allege or claim or assert in a wild, sweeping way in the Court of Appeal that this is a common cold is an assertion that really it doesn't bear thinking about. And to challenge it and to put forward the argument that there's a cure for the virus and it's hydroxychloroquine, vitamin C and zinc is such an absurdly, manifestly stupid claim or assertion that to comment on it at all would be inviting a complete waste of my time. But anyway, that's the Court of Appeal decision, or that's the Court of Appeal case yesterday, 20th of January 2021. O'Doherty and Waters challenged the constitutionality of the COVID-19 regulations and laws in Ireland, and the Court of Appeal has reserved its decision and hasn't indicated when it will issue its decision. Anyway, watch this space. I'll have a look at the decision when it is issued, and I will take a closer look at what the judges have to say and what they have to, what reasons they put forward for their decision and so on. Hope you find this video useful. If you do, and if you find anything of value in it at all, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.